Sorry to keep you waiting, Mr. Tony. Such lots to talk about in this case. But if we run into difficulties, we can run a bit later, if necessary.
Okay. My Lord, could I start by just picking up a couple of points that arose yesterday that I've reflected on overnight?
Yes.
The first one is my Lord's question about the sort of comparative exercise that might be carried out in terms of looking at the relative welfare traits of a particular breed. And the point that I just pick up here is that, and it may be relevant to when we look at the code of practice, that the breeds that are used, the breeding programs that are used, do of course change the nature of the animals that are farmed on a fairly regular basis. There's a cyclical basis on which the breeding programs come forward and produce refinements to the breed.
It's to some extent arbitrary, presumably, at what point you define a different breed. Arbitrary is perhaps overstating it, but really only at the point you're marketing it do you actually have to give it a name and call it, I forget what the names of the three breeds are that are in the spotlight in this case. Sorry, I've lost myself, but I mean, it's a helpful observation. What is a breed? It's all a spectrum.
Precisely, my Lord. And I think the simple point that I was making was that what is being considered is effectively an emerging picture that will change over time in terms of the particular traits of the particular animals that are in these quite complex and substantial systems of food production. And that is a reflection of the fact that there are ongoing breeding programs which will, and we'll come on to the code of practice, which will seek to achieve various objectives, which will include both questions of productivity and questions of welfare and other characteristics.
That's a helpful background point, but it doesn't really get us anywhere, does it? At any one time, there will be a breed out there, and a question will have to be asked whether paragraph 29 applies to it.
Precisely, there will be an animal that you can identify. My Lord, yes, just putting the context for the comparative.
Yes, okay, thank
you. The next point that I wanted to just come back on is we were talking yesterday about Ms. Thompson's evidence, and I just wanted to highlight people. I don't need to go into it in detail, but there's a second witness statement of Ms. Thompson as well in the proceedings. It's in the supplementary bundle starting on page 142. This was filed following the intervention of the RSPCA below, so it responded to the RSPCA's further points. And there is, I think, perhaps the most useful or comprehensive response to the RSPCA report, which is referred to by my own friend. It starts at page 145, paragraph 9, and goes through to paragraph 20. The comments there include the observation that one of the difficulties with the...
So which paragraph?
On paragraph 12, for instance, one of the comments is that all of the birds were reared in the same environment and provided with the same feed management, which might not have been tailored for the specific needs of the breed. In other words, if you take 4 different breeds of chicken but keep them in the same environment, you're not necessarily meeting all of their needs as best you may do. Then there's further methodological and reporting issues that are identified in paragraph 13, which I don't need to go through, but just to emphasise that there is a further analysis there of the RSPCA report.
Yes, that's something we've been thinking about, but it is the case, isn't it, or which is likely to be the case, that there will be some genetic conditions which are not susceptible to management by environmental changes.
My lord, that must be right.
Yes, some will, some won't. You may have a breed which needs a lot more heat or a lot more water, and if you give them a lot more heat, a lot more water, no health and welfare issues arise. But there will be some, to take the ludicrous example of breeding chicken, which effectively have no functioning legs at all. You say it's very far from this case, but suppose that were the case, wouldn't help. There's nothing you do about that environmentally, and that would mean that their welfare would inevitably suffer.
My lord, yes.
Yeah. Good. That's fine, but
precisely, and in my submission, that's really the heart of paragraph 29.
Yes.
I'll come back to
yes, thank you.
Sorry. I just then go to the statutory provisions more generally, and I'll pick up here the question that was raised yesterday about the enforcement provisions. So the Animal Welfare Act itself is at tab 3 of the authorities bundle. In my printed version, the provisions repeat and vary depending on where we are in the bundle, but if I'm working from page 46 of the bundle. Where section 9 is sidelined. This is the duty on the person responsible for the animal. And to be clear, that this applies to all animals that are within the scope of the Act, which is the animals.
I'm so sorry. I thought I was catching up with you. Where 146 of the bundle?
Sorry, page 46.
Page 46.
Tab 3,
that makes
page
more
46.
sense. Yeah, thank you. Yes.
So this is a duty that is imposed on all those who are responsible for animals, including, for example, the dog owner. The provision is that it's an offence if you fail to take such steps as are reasonable in all the circumstances to ensure that the needs of the animal for which he's responsible are met to the extent required by good practice. So that's a sort of overarching provision that would apply to a farmed chicken being conventionally reared, as it would apply to a pet dog. And then the animal's needs include the matters set out at subsection 2, which includes protection from pain, suffering, injury and disease, but also environment, diet and behavioural matters. Then what you may have regard to, in particular, any lawful purpose for which the animal is kept, and any lawful activity undertaken in relation to the animal. So you've got to think about why you're keeping that animal, and obviously then the question of whether you're farming or keeping a pet or using, for example, a dog for another purpose may come into consideration. So that's section 9, and then section 10 is at page 48. Now this is the first of the relevant enforcement powers. So this is a power to serve.
So sorry, I was just having one last read of this. Yes, sorry, where are we going?
To page 48 of the bundle in section 10 of the Act.
Yep, thank you.
Which is the power to serve an improvement notice, about which can require the person who keeps the animal to take steps to ensure compliance with section 9. So again, that could apply equally to a pet owner as it could to a farmer. The next relevant provision is at page 54, section 12. And that's the regulation-making power that under which WOFAR is made. The 2007 regulations are made. And I just note that this court in the Electronic Collars Manufacturing Association case, which is tab 17 of the authorities, no need to look to it now, I don't think, described this as a wide power to make regulations in respect of welfare. But for the complete reference, tab 17, paragraph 10, page 642 of the bundle.
So why does that matter? I mean, the regulations are what the regulations are. Nobody's suggesting they're ultra vires or anything. I mean, why does it matter that... Sorry, I'm just not picking the point up.
Well, my Lord,
why does it...
to know that this court has recently looked at the regulation-making power in the context of a proposal to make new regulations in respect of one aspect of animal welfare, and accepted the principle that in that case that there was a wide power to make such regulations.
It's meaning a wide power. I mean, the power, as my Lord says. Okay, thank you.
I'll leave it, my Lord. I'm sorry if I took a moment on that. Section 14 is then the next relevant provision, which is the code of practice. And again, just emphasising, as I did yesterday, that it's a discretionary power to issue and from time to time revise codes of practice for the purpose of providing practical guidance in respect of any provision by or under the Act.
Would it be within the power of the Secretary of State, if persuaded it was the right thing to do, to say some practical guidance about para 29, Schedule 1, is that this, that, and the other breed it is unlikely, or I take the view, because it wouldn't be a rule, my guidance is that keeping these, it's not possible to keep these breeds without detriment to their health and welfare, or perhaps more likely, it's not possible to do so unless you take the following special measures. You give them, whatever it might be, special feeding regime, or special temperature, or more space. You get the point. That is something the Secretary of State could do.
My Lord, yes.
I mean, the oddity about the code as it stands at present is that although para 29 appears in a couple of boxes, there's no actual consideration of it. Now, it may be because the Secretary of State didn't feel there was a need to, on what she knew at that time, to give it any particular guidance, whether of that character or more general. But she certainly could.
My Lord,
he certainly could.
Yes, he could. And as I'll say when I get to the code of practice, he hasn't given specific guidance on paragraph 29 in terms of its legal effect, or paragraph 29 as it applies to particular breeds of chicken.
Thank you. Sorry. We'll look at that again when we get there.
The next provision, just to pick up, and I handed up a couple of extra provisions. So, and I think I haven't handed you, but we should provide also section 18. It's not in the bundle at the moment, but I said yesterday that there was a power to seize animals. That's found in section 18 of the Act. I'll provide a copy to your clerks.
Thank you.
And then I did provide section 28, which is a power to inspect farm premises for the purpose of ascertaining whether there's compliance with regulations made under section 12.
That's what you've just handed up.
That's what's been handed up. And then
Thank you.
And then there's section 30, which is the prosecution provision, and then section 51, just to completely define what an inspector is, or who an inspector is.
You say, I think you may have said we've got some duplicates in the bundle, haven't we?
Yes.
Is that right?
There are quite a lot of duplicates.
They are duplicates. There's nothing special that I've failed to spot. They are just duplicates.
I don't think so. It may be easier if we provide to your clerks a single PDF version that just has all the provisions we want to refer to, and perhaps it can be substituted. But
Certainly not objecting to that, thank you.
So
and have all the provisions that both parties want to refer to.
Absolutely. So there's a comprehensive. My Lords, then if I could go to the 2007 regulations, tab 4 of the authorities fund dog. The court was shown most of the relevant parts yesterday, so I don't need to go through them. Starting with section 4, page 76, duty, and it's taking all reasonable steps to ensure conditions under which it is bred or kept comply with Schedule 1, and the matters that have to be taken into account in Regulation 4, sub-regulation 2.
So the way this works is, in fact, that all animals are protected by the provisions of Section 9. I think that you pointed out.
Yes.
That's the general thing. And then farmed animals, as defined in fact in Regulation 3,
yes,
are the subject of these regulations.
Yes.
So you have to be within the definition of farmed animals in order to be subject to these restrictions or requirements.
Yes, yes, absolutely. And in fact, I should have addressed it since my Lord asked about it yesterday. But Regulation 3.2, as my Lord says, is a farmed animal is defined, an animal bred or kept for the production of food, wool, skin, or other farming purposes.
So that in a sense, if we're looking at the sort of the starting point, the freedoms of what you can and can't do, you can keep any animal for any purpose, but if it's a farmed animal within the definition of these regulations, you have to comply with the regulations.
Quite, yes, yes. But whether it's a farmed animal is dependent on the purposes for which it's bred and kept.
Yeah,
rather than on the identity of the animal.
Absolutely.
So I can keep a pet cow.
Absolutely, but that was, if you remember, that was the point I made to you. Sorry, I didn't make it to you. So that was the point I made about the opening words of, made Mr. Brown about the opening words of paragraph 29.
Yes.
Which, in a sense, seemed to be, I think we saw, borrowed from the European
yes.
Legislation, with a sort of strange amalgam of Articles 1 and Article 2, but in truth, they probably could be paraphrased simply to mean a farmed animal can be.
I think that's right, because of the requirement under that definition for farm purposes.
For purposes,
so that's
yeah.
it's circular in that sense, or unnecessary wording.
Yeah. It could have been done more neatly had it not been the desire of the draftsman perhaps just to copy out the European wording, which doesn't, because the European legislation doesn't include the definition of farmed animal. That function is performed by Article 9.
Well, not quite. That's how I understand it. Without going into the legislative background, that's how I read the structure as well. And I just note in section 5 then that the additional duties, which include the duties that we're dealing with under Schedule 5A, are in respect of some particular animals that are kept for farming purposes. So the court will see in Regulation 5.1 the list of those different schedules that apply to particular animals. The next point is Regulation 6. I don't have any further submissions to make on that. There was an exchange yesterday in the court about the duties on the person who is responsible and employees, and then Regulation 7 is the offence provision.
I mean, just looking at 4.2d again, given that the person responsible for a farmed animal must have regard to its physiological and etiological needs in accordance with good practice and scientific knowledge, where practically, other than the Code of Practice promulgated by the Secretary of State, is your average person responsible going to find that out?
Well, my Lord, I don't want to define it as limited to the Code of Practice because there aren't necessarily codes of practice covering the full range of farmed animals. So there may be farming circumstances which just aren't dealt with in particular codes of practice. We've zoomed in on one particular code of practice for chickens.
Okay, well, let me rephrase my question. where is a person responsible for the keeping of chickens, conventionally reared meat chickens, going to acquaint themselves with the material necessary to fulfil their duties under paragraph 4.2d, other than a code of practice promulgated by the Secretary of State?
Well, there are, as I understand it, there are specific instructions given by the breeders of meat chickens to the farmers who are growing those chickens from chick to slaughterhouse, and those instructions will be breed specific. So they'll say about the quantities of feed, they'll say about details about provision of ventilation, or whatever it might be, that's specific to that breed. So there is a lot of information there.
What, put out by the people who are selling them?
Yes, about how that breed should be kept.
Well, okay, but they want to sell them. Yeah, but is that a satisfactory way of, given the importance that appears to be attached to this, and indeed the fact that there is, I mean, is that just the Secretary of State can just sort of say, okay, well, I don't need to put out a code of practice, let's just leave it to the people who are selling the breeds to inform?
Well, my lord,
I mean, who regulates that? Who regulates what's said by the sellers of chickens?
it will be regulated through these regulations, through the application of these regulations, where particular issues arise. It will be possible to say, well, for example, in feed requirements, which I can show you in Schedule 1, for this particular breed of animal, everyone knows that you should feed them X, Y, and Z on these intervals. And if it could be shown that a particular farmer was bringing in thousands of day-old chicks into the system, but then ignoring the guidance that's been given by the producer of those chicks about how its needs to be met, then you would say, well, that's breach of Regulation 4.
So the Secretary of State could just absent his or herself from this area completely by just saying no code of practice?
Yes, absolutely. In the sense,
really?
Absolutely.
Realistically, practically?
Absolutely, my lord. Absolutely. There's no requirement to adopt a code of practice.
I know there's no legal requirement. You've made the point. It's a discretion. But is that real world?
So, my lord, as I'll show the court, these provisions are not just concerned with meat chicken. I know the court knows that, but I do have to emphasise that. So, in the context of meat chicken production, then there is a code of practice. There's obviously a large degree of interest in the area, and there's obviously a particular concern. The scale of production is vast. So there is a code of practice, and the Secretary of State takes an active interest in the area. So in that context, I don't seek to persuade my lord that he shouldn't treat it as surprising if there wasn't a code of practice. That there may not be a code of practice, but I agree, it's likely that the Secretary of State in this area would think that guidance should be given. But we're talking here about regulations that apply to all farmed animals.
I'm assuming, quite interesting to know, that for all the major types of livestock farming, there are codes of practice, for example, about dairy farming, intensive pig rearing. I don't know. But possibly not for chinchilla or...
My lord, I don't know.
No.
I don't know, so I'm not going to try and guess, but we will check.
That, no, quite.
And I'll be able to make some comment on the scope of what's covered by code.
But I mean, my lord is certainly right to this extent. Of course, he's always right with everything, but he's right that the codes of practice play an important part in the regulatory system.
Absolutely.
When there are any. It's really focused, the duty to make sure people know what they're doing is framed by reference to familiarity with the code of practice.
My lord, it is...
That's what's clear from Para 6, Regulation 6.
Precisely, framed in Regulation 6, and also, of course, because under the prosecution, under Section 12, it makes clear that if you can show you've complied with the code of practice, then that's going to be...
Yes, exactly. So at least at those two parts, it's central. Obviously.
Yes. So it effectively, with the carrot and stick, the producer is going to be encouraged to comply with codes of practice. But
we've slowed you down too much on this. But you're going to any more in the regs.
I think the court has the relevant parts on 7 and 8 in terms of the identity of the prosecutor. Can I then go to Schedule 1?
Yes.
And just to note, of course, this is general conditions for farmed animals. It's not specific to meat chickens, where there is, for conventionally reared meat chickens, there's specific provision in Schedule 5A. My observation about these provisions, and I won't go through them line by line, is that they are broad. They cover a range of different topics in terms which are relevant to welfare. They are intended, as is clear, to ensure that suffering is avoided and that the welfare of the animal is maintained. They include, for example, the freedom of movement in paragraph 9, which is framed by reference to restriction of movement in a way as to cause unnecessary suffering or injury, buildings and accommodations, so on. Before I come to paragraph 29...
Out of curiosity, is the phrase unnecessary suffering or injury a regular test? Was it just peculiar to Reg 9?
That is the...
I notice Reg 28 talks about slightly different, likely to cause suffering or injury. It doesn't say unnecessary.
Yes.
23 uses unnecessary suffering or injury.
Those words are used. There isn't a single use that you can track through.
Yeah.
What I do notice is that unnecessary suffering is the header of Section 4 of the 2006 Act. So that
yes, I see.
Perhaps what unnecessary suffering is, and I don't believe injury is separately defined. But I think it's fair to say that welfare connotes more than avoidance of suffering and injury, because recall we went to Section 9.2 of the 2006 Act. So the heading is ensure welfare.
Yes.
Then 9.1 says the needs of the animal, and then the needs of the animal include various things, one of which is protection from pain, suffering, and injury.
Sorry, I wasn't keeping you pace with you there.
Section 9.2 of the 2006 Act. So that is page 46 of the bundle. So
yeah.
Duty to ensure welfare, and then the word welfare drops out. 9.1 meet the needs. So meeting needs and welfare, I say, are being used as an equivalent. And then 9.2 needs include 5 things, one of which is protection from pain, suffering, injury, and disease.
I mean, it's odd. I'm not sure. I suspect this will be a rabbit warren which won't lead anywhere. Probably getting my natural history wrong. But the structure of the 2006 Act distinguishes between prevention of harm and protection and promotion of welfare. But the concept of suffering comes into both.
Yes.
But in the prevention of harm bit, a key concept is whether the suffering is necessary
Yes.
or unnecessary. I imagine that there's a good deal of case law about that.
There is case law about that, because the unnecessary suffering provisions, as I recall, predate the 2006 Act. I think that's been a long-standing
Yes.
criminal test.
The thought I'm just having, in case anyone wants to pick it up, is that we may, in looking at Regulation 29, have to find some sort of, no, it's a red herring. I'm not going to go there.
Well, I do notice, as well as the need to be protected from pain, suffering, injury and disease, there's also a need to be able to exhibit normal behaviour patterns.
Yes.
Which is perhaps something which we find an echo of when we look at some of the questions of the what's the wording?
Ecological needs.
Yeah,
it's the etological. That I was thinking. I was trying to remember the word behavioural needs. I think I translated it as.
So that's obviously natural behaviours. I don't quite know why we have.
But the reason why, just so I can finish off this thought, I don't want to alarm anyone. I did think at first that it might be useful to try and interpret Regulation 29 in a manner consistently with the concepts in the statute itself. But it's a provision of a different kind, with its own, as it were, self-contained test. And it's probably unwise to try and gloss it by reference to other provisions, even though we're obviously, broadly speaking, all in the same statutory regime. So I'm not proposing to go down that route.
My Lord, I would submit that that's the right approach, to not try to link it back, because what we see in the Act and regulations is the Act setting up some quite general propositions about the way in which animals' needs are met. Say, for example, suitable environment. And then Schedule 1 setting out what that might mean, which includes, for example, not keeping animals entirely in the dark. And then Schedule 5A, when you get to the detail of this particular farming system for chickens, says more about those points in terms of, for example, page 87 of the authorities bundle, 5A, Schedule 5A10, lighting with an intensity of at least 20 lux during the lighting periods. So you go from a general suitable environment through to, that includes lighting, through to lighting at this lux level for this number of hours per day. And that's the hierarchy that you see right the way through. Now, the general requirements in Section 9 remain, as do, and then once you get into the regulations, the general requirements in Schedule 1 will apply to all animals and apply to eventually red meat chickens, and then 5A, further requirements. So it's that hierarchy that I think is important for understanding how paragraph 29 sits in the wider regulatory framework. In terms of paragraph 29 itself, I've covered quite a bit of...
Just before we go to 29, sorry, can we just pause? Were you going to go to 27 or 28 at all?
My Lord, I wasn't, but I'm happy to go back to it.
Can I just look at the structure of 27 for a second? 27s, we haven't looked at it before. So it says, other than say, the food, water, etc., that was mentioned in the preceding sentences, preceding paragraphs, no substance may be administered unless it's been demonstrated that the effect of the substance is not detrimental to the health or welfare of the animals. Now, I read that as saying you just can't unless positively you can demonstrate that the effect of the substance is not detrimental to the health or welfare of the animals. I mean, is there any other way of reading that? Or are you happy that that's the way of reading that? No, you can't unless you can demonstrate affirmatively that what you're about to give the animals is not detrimental to their health or welfare.
Yes, I think that's right. That it would need to be shown, based on science, that what we're giving to that animal is not detrimental to itself.
And you just look at the structure. Is that the same structure we find in paragraph 29?
No, well, no, because it doesn't include there any concept of what's being kept. So it's just a prohibition on the types of substances rather than on the animals to which they're being administered. So I think the structure is different there. So you simply there's a prohibition on using those substances for farmed animals. It doesn't tell you anything about the animal itself.
Yes. So then you're about to come to para 29. I forget. Forgive me if we asked you this yesterday. We certainly discussed it with Mr. Brown. The heading breeding procedures contains two rather different kinds of provision. 28 is truly about breeding procedures.
Yes.
29, though I can see a rather loose link because it is about breeds, is actually a different kind of provision. And we don't get much help from the fact that it comes under the heading breeding procedures.
No. Although, my lord, when I read it, if one sort of disregarded the word procedures and the suggestion and what that suggests about what breeding is concerned with, then actually the heading breeding works for both 28 and
Yes, no, I see that.
But certainly 28 is concerned with breeding procedures in a narrow sense because it's concerned with how you actually go about the act of breeding the animal. Whereas 29 is concerned with the animal choice effectively.
In a sense, but not the way it's drafted. It's saying you shouldn't breed these animals at all.
Yes.
It's not saying that, it's saying you shouldn't keep them.
You should exclude them from farming systems.
Yes, exactly. But that, in the broad sense, that's why it fits in under breeding.
Precisely.
But it's not, it is actually it's dealing with a different problem in a different way.
And what is clear, though, in my submission from the heading and from 28 and 29 and the sequence that they sit in, is that this is concerned with the mischief is about the sophisticated process of selection through breeding programs that leads to animals which have particular problems. That's what it's really concerned with.
Yeah, hang on 1 second. And if you have one at your fingertips, that would be great. If you don't, can you tell those of us who've taken a long time since we read Richard Dawkins what the difference is between a genotype and a phenotype?
My lord, so...
I mean, it's easy enough for me to say, broadly speaking, it means what we call a breed, but actually it would be quite useful to know correctly what it means.
A genotype is the genetics of the animal that you could, in modern technology, take a blood prick from any animal or human and profile them genetically. The phenotype is how those genetics are in fact expressed. So, in other words, the way in which that sequence of DNA will materialise into a living thing in the real world.
Thank you.
So phenotype is about the expression,
The observable characteristics.
the observable traits in the way it's described as with the old science.
I suppose, going back to my Greek, which is a long time to do, it's to do with, phino is to show, isn't it? So, as in phenomenon.
I'm sorry, I missed the
As in the word phenomenon.
phenomenon, precisely.
Yes.
Precisely, yes.
Okay. Thank you.
What is precisely? What is shown? Just a few further submissions, if I may, on paragraph 29 itself and this language. We are concerned, as we've already addressed this morning, with animals kept for farming purposes. There is a reasonable expectation test, and in my submission, what that means in any ordinary use of that phrase is that it's possible to keep that animal without any detrimental effect.
Hang on 1 second. Well, why do you get that from reasonably to be expected? You get that from they can be.
Well, I think it's the two together. I think if it can reasonably be expected that they can be. In other words, it's talking about not a certainty that every animal will avoid detriment to their health or welfare, but that you can expect that they will, because it's possible to keep them in a way that will avoid such detriment.
Just possible, or likely, or?
Well, that begs the question as to how to keep, but that you can create circumstances in which you can keep them for farming purposes.
Can must mean can in practice.
Yes.
I agree then the phrase in practice involves a lot of interpretation in particular circumstances, but your accepting principle means can in practice, not theoretically.
I accept that can in practice and add for farming purposes. So we don't need to go to the sort of extreme exchange we have, I know, merely for the purpose of testing the proposition, but the sort of one-on-one provision of care for a particular hen. No, that's not required for the can be kept for farming purposes, because obviously if that was required, then you can't expect that you can farm this animal.
As you say, you said that yesterday.
So in my submission, that reasonable expectation point is concerned with the possibility that you can keep them, and not the certainty that in all circumstances they will in fact be kept without detriment to health or welfare. The second point, which seems to be common ground, is that the conditions that we're concerned of that cause detriment must be linked to genetics or observable traits. I don't think that's in dispute. And in this sense...
Sorry, say it again. The conditions that cause...
The conditions
detriment.
that are causing detriment to health or welfare must be linked to their genetic or observable traits.
I see.
So we're concerned here with the animal. And in this sense, in my submission, we're concerned with the inherent risks to health or welfare of the breed of animal concerned.
So is this drawing the distinction which my Lord made earlier between conditions which are susceptible to improvement by the way that you look after them, and those which are not?
My Lord, yes, because the farming keeper, the farmer, has to meet that animal's needs. See all the regulations we've touched on.
But if we apply that to what are said to be the problems which fast-growing chickens have, it looks to me, at any rate, if the conclusions in the RSPCA report are right, as if you can't do much or anything about the problems which arise out of the heart condition and the legs not being strong enough. If the RSPCA are right to say that because of the way these chickens grow, they have a high incidence of heart problems, and if they're right to say that their bones don't mature strongly enough to support their weight, then you're not going to be able to improve that by the conditions in which you keep them. Contrast, perhaps, what is said about the other major problem, which is the leg burn, or whatever it is, from not being able to move about very much, which you can do something about by reducing the density. Now, obviously, the RSPCA report is only one report, and you have your criticisms of it, etc. But if those conclusions are scientifically valid, would the application of paragraph 29 lead to the conclusions which I was suggesting?
Well, I know my lord asks it on the assumption, but just to be absolutely clear, the Secretary of State doesn't accept that those conclusions are right. That
I've got that point.
If that is what the RSPCA report is saying, and again, it's not the paper doesn't teach that.
Okay, we have got the point. If that's what it's saying, and if it's right,
and if it's right, then I think then you come to the question of whether you can nonetheless adjust the systems in which you're farming to ensure that you can expect that the animal can be kept without detriment.
Yeah, but that's the question you've just been asked. That's the question you've just been asked.
Well, my lord, so that the RSPCA poses that question or tests that question in a particular farming system, and the point is that you may be able to adjust the farming system.
We understand that, but what my lord is putting to you is that the particular conditions, two of the particular conditions that RSPCA identify, don't give us the caveats again, we've got them, are of a character which it's very hard to see how they would be changed by a different farming system.
Well,
if you put it crudely, if your legs won't bear your weight, that is a problem that will happen however much density, however space you have, and so on. You may not, if that were the conclusion, if that seemed to be the conclusion, is there any reason why we shouldn't say so in our judgment? With, of course, all the caveats that the Secretary of State doesn't necessarily accept the RSPCA science, and that may not be what the RSPCA science says. It's what, however, Mr. Brown's clients say it says.
So, my lord, can I just take that stepwise? Should the court say that? Well, I do say that there's a bit of a risk here of the court working off a hypothesis, not least because of this is an area that's a fraught area of public policy.
Yeah.
And so I know it's with the caveat, but I do sound a word of caution about using a hypothetical that is suggested to be derived from the RSPCA report, but it is not, and where the RSPCA report is contested by the Secretary of State.
I get that, but you will appreciate the way this litigation has been set up, and it may not be anyone's fault, or you may say it is the claimant's fault, but the point we've got to, it's been dealt with below in the way it has, it's been dealt with, is that we're to some extent going to be considering the position in the abstract.
In the abstract, precisely.
But that's not terribly, that's inherently more difficult, because in the real world, in order to test abstract propositions, one wants to try them out on real examples. And the only examples we've got here are the ones about fast-growing chickens. And the only material we've got about identifying the problems is the RSPCA material and the reports lying behind it, although we have, of course, Ms. Thompson's commentary on them. So one thing we're just going to have to think about in writing any judgment, and that's why I thought it right to test this with you, is whether it's appropriate for us to say if what the RSPCA says is right, and if it says it were the whole truth and not just the truth, then it's hard to see how this could be ameliorated by changes in conditions. In other words, some sort of commentary on where our conclusions on the meaning will be likely to go if the evidence stands up. You follow me? And I guess
yes,
you're going to say, don't go there, it's too dangerous,
well,
it's an area of public controversy.
So this case started with the claimant saying that the court should find that the Secretary of State had gone wrong by not proscribing these breeds because of the evidence in the RSPCA.
Yeah.
So that's step one.
That bit they failed on below insofar as they pursued it at all.
But, my lord, they failed on a set of really important public law principles, namely that those questions of scientific judgment are not for the Judicial Review Court. And when faced with evidence from the Secretary of State that those points had been considered but had been rejected, they dropped the argument.
Yeah.
Now, if they hadn't dropped the argument, the way Sir Ross Cranston dealt with it was to say, I'm not being asked to rule on the science, because he wasn't. Mr. Brown was incredibly clear about that below. If they hadn't dropped the argument, then it would have been rejected on the basis of very well-established public law principles that the court should not sit as the arbiter of those technical matters.
With respect, interesting that this debate is, I actually didn't understand Lord Justice Mills to be asking this question to get you into an area which is policy. My understanding is that the question was being asked because we're testing how the regulation works. And so what you were being asked, and I don't think I've still heard the answer, is on an assumption, which just happens to have been drawn from the RSPCA report because that's just an assumption. It's a basis of where we've learnt a bit about chickens and how they suffer, or whatever the characteristics they may have. But on that assumption, how does this regulation work? And my understanding is you were being asked a question about how the regulation worked, not about the policy judgments that were on the evidence or anything like it. It's just if you have a situation in which it is shown that chickens of a particular breed suffer particular genetic traits, which means that so that their hearts are too inefficient to support their body weight, the mass that they have, or their legs are insufficient to support it. Is that the sort of situation which is addressed by paragraph 29? Would paragraph 29 lead to a hard line which just simply said you can't keep those animals for farming purposes? And my understanding, and I'll be corrected if I'm wrong, is that you were being asked the question as a matter of testing how we look at the interpretation of paragraph 29.
Well, it was a way of testing. I think the proposition which you made, Mr. Turney, that the question is whether you can adjust the conditions to expect that the animal will grow without detriment.
My lord, yes. So I'll take the...
Perhaps I will let you answer, but the answer in principle I thought you gave earlier. The answer in principle was yes, but irrespective of the facts of this particular case, you can imagine conditions where which can't be adequately coped with.
Yeah, absolutely.
As a matter of principle. Next question is, my old question really focused on this case, whether as an example or whatever.
So, my lord, the answer is as my Lord Justice Underhill just said. Yes, there may be conditions for some animals linked to their genetic or observable traits that mean that they cannot be kept without detriment, no matter what you do in terms of environmental improvements. And that indeed is, I say, the mischief of paragraph 29. But even taking the RSPCA report at its highest, which is disputed, this case is nowhere close to that.
Yeah. Well,
and my lord, I do emphasise that it's not just the RSPCA report that was before the court below or that has been considered. We had huge numbers of reports below, and indeed, as you know, as the court will know, there was some toing and froing over how much this court should see in the bundle. And because of its centrality,
not sure I did know that, but still.
Because of its centrality to the way in which the claimant put the case, it was agreed that the RSPCA report would go in, with relatively limited further documents being put in apart from the science underpinning it, which doesn't reach the conclusions that the RSPCA reached based on the scientific study. So the RSPCA say, ergo, you shouldn't be keeping fast-growing breeds, whereas the study does not say, ergo, you should not be keeping fast-growing breeds.
Well,
and there's a list. There's a list in Ms. Thompson's statement of some of the reports that were considered, and the court will see in the British Poultry Council's intervention reference to a series of other studies, which they say, and the Secretary of State, I think it's fair to describe, largely agrees that those studies show that environmental factors are the driver of the differences that can be observed in terms of fast-growing breeds versus slow-growing breeds. So that it is environment and it's not genetics. Now this is an area of contested science as well as contested policy, but that's what that evidence points towards, that it is environmental conditions that are going to be driving the differences. And that's really the point that's made in response to the RSPCA study, not that it is disregarded, but that having thought about it carefully, the difficulty is that it has a number of methodological flaws if it's going to be relied on to reach a conclusion that you cannot keep fast-growing breeds.
So is what you're saying that if we had been shown the totality of the evidence, which the way this hearing has been set up, we haven't been, we would be disabused of any feeling we might have that it was obvious that the health conditions described by the RSPCA could not be ameliorated, could not be removed by changes in the regime under which they were kept.
My lord, yes, because the Secretary of State's position is that the environmental factors are going to be the key driver. And the further point, which I think I made briefly yesterday, which is that none of the conditions described is unique to the fast-growing breeds. They are conditions which may be more or less prevalent in particular breeds. So in other words,
that's quite the answer, though, is it? I mean, you may say the environmental factors are a key driver or the key driver. I think the question is that was originally posed is, if you genetically engineer a chicken to have certain characteristics, is it possible always to address them by environmental adjustments?
And my answer to that is no. One can envisage a case, and paragraph 29 is dealing with a case where, having made the environmental adjustments that you can to accommodate the need of that particular animal, you still cannot expect that it can be kept without detriment.
But you're saying, in answer to my contribution to this line of questions, it would not be right for us to, in addressing this question as part of the construction of Para 29, to draw even caveated conclusions about how it would apply to the facts of this case.
My lord, yes, because I'll come on to this briefly on the question of the declaration, but one of the reasons that the courts are disinclined to deal with hypothetical disputes is because it fails to illuminate facts of the case. But we're in the meaning of the provisions. You really need to have some substance to the dispute to be able to understand the practical implications of any finding. The difficulty here, the real difficulty in my submission, is that the court is stuck between a factual matrix on which it's being told it cannot draw any conclusions, and a purely hypothetical argument.
Now, I understand that. We are where we are, and we didn't have to. It's too late for us, and I don't think it would be helpful for us to say, well, we're simply not going to deal with this appeal. We have got to deal with such points as we helpfully can deal with in the appeal,
My Lord, yes.
which effectively mean focusing on what Sir Ross Cranston said about the meaning of para 29.
My Lord, yes. And I haven't...
And if that's, in an ideal world, very unhelpful, or not as helpful as one might wish, because it doesn't apply to the facts, I'm afraid that's where we are.
My Lord, yes, quite. And that's entirely my submission. And that I don't seek to dissuade the court from making findings on the meaning of paragraph 29. But what I do say the court cannot do on the case before it is make any conclusions by reference to conventionally reared meat chickens or fast-growing chickens
Okay,
in particular.
we got the point. Sorry, that's taken a little time and probably driven you off your course, but it's actually been valuable. We will try and be fairly disciplined in our interventions from now on. We'll see.
My Lord, I think I addressed the point yesterday, but I do say that that the interpretation that's advanced by Mr. Brown on behalf of the appellant is paragraph 29 is one which tends towards absurdity, or at least an unworkable conclusion, because it necessarily requires some sort of threshold to be set, whereas the interpretation which I say the court should favour does not, because you can make a judgment, well, the criminal courts, if necessary, can make a judgment at the end of the process. Has this person done what they can to meet the animal's needs, by which I mean complying with the general provision in section 9, with the general provision in regulation 4, and with any specifics that might arise. And nonetheless, is that person facing inevitable adverse consequences to health and welfare because of the genotype or phenotype of the animal itself? And that's why I said yesterday that the correct way to see paragraph 29 is as that backstop, whereas my learned friend says it's a sort of logically prior question to any keeping of any animal. And in my submission, that leads to a very difficult position, which I think the absurdity is made clear in him saying, well, if there was 0.1% chance of, then that animal would be prohibited from being kept for farming purposes. And that, of course, must be absurd, because without seeking to give biological evidence, it seems improbable that any species of farmed animal could be kept with a guarantee that no individual within that group will suffer health or welfare issues during its lifetime as a result of its genetics or its observable traits. There will always be a lame sheep or a tumour on a pig, whatever it might be. There will always be that. And if you come to the different conclusion, which my learned friend impresses in the court, then you have an unworkable provision that would effectively ban the keeping of farmed animals. So that's why I say that my interpretation works in practice, and it works in terms of the language of the provision and how it sits in the overall structure of the regulations. My Lord, I just very briefly wanted to pick up a couple of references to the judgment on this, and I accept the court observation yesterday that, in a sense, you're being asked to interpret paragraph 29. It might not help to plough through what Sir Ross said on it. But if I could just go to page 61 of the core bundle and paragraph 89 of the judgment. I think there was some debate about the last sentence of paragraph 89. The result is, as far as keepers of animals are concerned, paragraph 29 should focus on their duties with the choice of breed kept. Now, I see the point that's made, which is not about duties, but it's about the breed. But I read that, and the court might read it as, the result is that as far as animals are concerned, paragraph 29 focuses on their duties as to the choice of breed kept. That's certainly how I'd understood it in the wider context of what's said. If I'm wrong about that, then it may be the judge's observation there is inaccurate. I do, in respect to paragraph 94, I accept the court's point that the word deleterious probably is an unnecessary substitute, detrimental. I think both connote.
Is that 94?
Sorry, paragraph 94 of the judgments.
Oh, yeah, sorry. Yes, that's the first. Yeah, sorry. That first comes up at 92.
Oh, sorry. I think deleterious is, both connote some material negative effect, but I agree with the proposition that it's probably not helpful to substitute deleterious for detrimental, and I don't suggest that needs to be substituted.
Well, or indeed obvious.
Well, I think obvious is a useful word.
Well,
because
that's not there either. I mean, that's not in. It's not in paragraph 29 either.
Well, my lord, I think in this sense, obvious is important because, of course, we're talking about, amongst other things, the genetics of an animal, and therefore it must be some observable detriment.
Well, if you'd be content for us to substitute observable for obvious, some of the sting goes out of it.
But, I mean, is that right? I mean, if I can ask, I mean, some of the sting may come out of it, but to take Lord Justice Mills's comment about, for example, a genetic modification that makes the pulmonary systems of a chicken inadequate to cope with their body weight, such that it's inevitable that at some point they'll just drop dead. I mean, that's, you would have thought, detrimental to their health, possibly even to their welfare if they become short of breath, etc., etc. Just imagining it as a human.
But I would say that's obvious.
Well,
if your animals are keeling over.
Well, it's only obvious when they keel over.
Well, but my lord, that's the point. It needs to manifest. There needs to be some. You need to be concerned with detriment that manifests, rather than hypothetical detriment.
You're never going to be concerned with a detriment that doesn't manifest itself because you won't know it's there.
Well, my lord, perhaps that's it, and perhaps the word obvious then is unnecessary. But because on my reading, and I think actually there's common ground on this, that we're concerned with the inherent characteristics of the animal that's being kept. Starting with inherent characteristics, it must feed through that you then need to see the adverse effect to understand that the inherent characteristics are causing the problem.
Yeah.
Yeah, but as long as you're not suggesting that, for example, if you conduct postmortems on chickens to find out why they died, and if the answer is because their pulmonary systems weren't good enough to cope with their body mass, that's observable in that sense, even though you wouldn't know it necessarily during the lifetime of a chicken. You couldn't watch it minute by minute. I mean, that's why I just think observable is a very strange word. What does it mean? Does it mean it must be apparent to the observer looking at the live animal?
Well, I think it has to be apparent. I mean, that is, it must be an apparent impact on health and welfare, because
I think all this proves is that, which I think you are broadly accepting, that it's perhaps undesirable to substitute other language for the language of the statute. That doesn't mean that one doesn't need to think about, if it's a real problem, questions like, well, we're in two questions about detriment. Does the detriment have to manifest itself in every individual in the breed? Or is it enough that it manifests itself in only one? And that question I think we have already discussed yesterday. You have your submissions on that.
My Lord, yes, I think I have addressed that for you so far as I need to. I think, well, I accept the proposition it might not be helpful to add words by way of gloss. I think what I do say is that this is concerned with, at the risk of introducing yet further word, with a patent detriment. In other words, one that is not simply a risk, a genetic risk that does not materialise. It's one that you will expect to materialise.
Right. Well, in a sense, obviously, but a genetic risk, if it's a real risk, will materialise. It's just a question of in how many cases it will materialise. I mean, a classic form, I don't really think we should go over this too much again, but just to give you one more. A classic form of genetic characteristic is a vulnerability to a particular condition. And that means some people with that, more people with that DNA will get it than won't. Sorry, I'll start again. Than in people with different genetic makeup. So that concept of vulnerability surely is included here, but that will inevitably mean that, given any given population, some individual animals will manifest the detriment and some won't. But it will be an inherent characteristic of the breed.
But to use a practical example, it might be an inherent characteristic of some farmed animals that they're not very resilient to the cold, and therefore they need to be kept inside if the temperature drops below 10 degrees or whatever it might be. Now, that inherent latent risk of developing pneumonia by being outside is not one that is caught by these provisions, because it would have to manifest, and therefore when you bring the animal inside as part of your good husbandry, you can reasonably expect that animal...
I see. I'm not sure what point you're making. If the point you're making is the one which you made, which we've already done to death, and I'm with you on, for what it's worth, that some detriments can be avoided by good husbandry or special husbandry having regard to that particular risk, fine. But in the case of one that can't, which you've agreed in principle there are some, it doesn't, surely you shouldn't be keeping the breed if only, let us take a neutral number, half of the individuals in the breed will actually manifest the defect during their lifetime.
Well, I think that then goes into what the reasonable expectation of the farmer would be in the circumstances.
Yeah, all right. No, but let's suppose a reasonable expectation is that half of them will manifest the detriment during their lifetime. And that is because of a genetic peculiarity of that breed. That must be covered by this, mustn't it?
Well, my lord, I don't think I'd say it's half or a quarter or three-quarters. I don't think I would pick myself.
Well, okay, but the science might present you with a case where it was half, and I was just trying to choose a non-silly example about 99% or 1%.
No, my lord, yes, but I don't think I'd necessarily accept that there's some threshold that half the population where you say, I cannot expect this animal can be kept without detriment.
But I think, my lord, to put you, I mean, I think you've mixed up, with respect, I think you mixed up 2 points. If, as a result of a genetic modification, a particular breed of animal is vulnerable to illness, a particular type of illness, then it is potentially caught by this. By caught, I mean this may apply to it. Now, if you can take steps to ameliorate that vulnerability, so, for example, by keeping the animals at a higher temperature or bringing them indoors when the temperature drops, then you're not prohibited by paragraph 29 from keeping that animal.
Because it weren't reasonably expected they'll suffer the detriment.
Yeah, but if there are some vulnerabilities caused by genetic makeup which do not permit of being alleviated by the husbandry or the stockholding techniques that we've been discussing, then you're caught and you are prohibited from keeping them under paragraph 29. Isn't that the structure of it? So for you to say you're not caught, I mean, just got to be careful what you mean by not caught. I think you are potentially caught, but may have a means of dealing with it. But to say that a genetic modification that creates a known vulnerability to a particular illness just isn't addressed by paragraph 29 at all, if that's what you were submitting, seems to me to be going to.
Just to spell it out, a known peculiar vulnerability, i.e. a much greater vulnerability than the risk that we all have of some particular illness.
The difficulty is, I don't, and this is the problem with abstraction, that I don't know if that's right. I don't know if that's right.
But I'm trying to understand the structure of this paragraph 29. Yeah. I'm not trying to get into any particular thing.
No.
I'm just trying to understand. I thought you submitted a moment ago
that it would have to be patent.
A known vulnerability caused by a genetic modification to a particular illness was just not within this paragraph at all, because it's not obvious. It's not observable, and if that's what your submission was, I thought that went back too far.
That's not my submission, but it has to be something that does in fact manifest. The detriment
must manifest itself. But the question I was asking is about in what proportion of cases.
Well, and my lord, that is the point. That on my interpretation, I don't think needs to be resolved in the abstract, or can be resolved in the abstract, because on Mr. Brown's interpretation, he says you should resolve that as any proportion, completely unworkable. I say, no, you come to the facts of a particular case, what is the reasonable expectation? Now,
I think we have gone over the ground. I'll ask you one more time. What if the reasonable expectation is that it will manifest itself in 50% of cases? Is that then a case that falls within paragraph 29?
I don't think you could say that in the abstract.
Fair enough. I have your answer, and I will think about it, because this is all very difficult. I agree. Right, we must move on, mustn't we? Can I just say, if your time is short, 2 things. You may have to borrow some of Mr. Birding's time. Also that we did sit 10 minutes late. But if you are still pressed for time, then I think we do want to hear you on the code of practice.
My lord, I was going to come to that. If you've heard enough from me on paragraph 29.
Well, we discussed a lot of aspects of it, but if there are any aspects that we haven't discussed, obviously now's the time to do it.
My lord, no, I was going to move off it.
Thank you. No, I certainly feel we've had all the help we could More.
All the submissions, at least.
Reasonably expect.
All we could reasonably expect, or even reasonably hope for. So, from both you and Mr. Brown on this difficult question.
I'm very grateful. My Lord, I'm going to do as Mr. Brandon and deal with what's ground one of the grounds of appeal last, which is whether or not a declaration is appropriate.
Yes.
So I think ground two, the meaning of paragraph 29, has been covered.
Yes.
So I move now to ground three, which is the code of practice.
Yes.
Can I, to set the context for that, just pick up one more reference to the authorities bundle than what you saw yesterday, which is tab 19 of the authorities bundle, page 699 and following. BF Eritrea Supreme Court.
Yes.
And the court yesterday was taken to Lord Sales in A and the Home Secretary, which is the previous tab.
The two cases were sort of basically decided at the same time, weren't they?
They were, and Lord Sales just revisits the point of principle in BF at paragraph 52, which is on page 718.
Lord Sales and Lord Burnett.
So, I'm sorry, Lord Sales and Lord Burnett, and it was
Yep.
the same for both in both judgments. And it's that statement that that I just emphasise.
Should we just read the whole para and then?
Yes.
Yes, thank you.
So in those circumstances, and given the discretionary nature of the power to issue a code of practice, my starting point is that it's not a requirement for the Secretary of State to provide an interpretation or analysis of what paragraph 29 means. The second submission is that in the code of practice, the Secretary of State has not provided such an interpretation or analysis. If I can turn up the code at page 301, 297 it starts, 297 of the supplementary bundle.
But you don't say that if the Secretary of State does decide to issue a code of guidance, that it shouldn't be correct. I mean, it should be accurate.
And that's the point. That's the point in A, which is that the Secretary of State may issue guidance within the field, but still not say anything about the law.
Yep.
But if the Secretary of State decides to give definitive guidance about the law, he must properly direct himself as to the law.
Yep.
And effectively treating this sort of statutory guidance in the same way as you would treat any other policy, which is that it's probably the wrong place for setting out what the law means, but in some circumstances the Secretary of State may need to say that in his application of the law, with whatever function it might be, they will treat the law as being X.
Yeah, but, I mean, you're not saying this. If the Secretary of State says in a code of practice or guidance, you can do X, and in fact, on the proper interpretation of the statute, a person cannot do X, then the court can say the guidance is wrong.
Yeah.
Well, the Secretary of State could either say, okay, well, I won't say anything about it then.
That there's a legal error in the policy concerned, or the guidance concerned, and accordingly the court can grant relief. And as my Lord says, yes, the Secretary of State can then say, well, I'd be better off saying nothing at all about the law, and giving just guidance.
And if the Secretary of State does say anything about the law, it is particularly important that she should get it right in view of the provision in the Act that compliance with the Code of Conduct tends to establish innocence and non-compliance tends to establish guilt.
My lord, yes,
Because that would correct itself to some extent, because if there was a prosecution and they got the law wrong, the court, in theory, would be able to say,
Well, not if it's the magistrate's court, because they wouldn't give a particularly authoritative reasoned judgment. They would simply, or might simply, look at the fact that the defendant had in fact complied with the code of practice, albeit the code of practice got the law wrong, and acquit.
yeah.
My lord, I think I accept my lord's proposition. I was just having to think through the logic of it, but I think it is for that reason that it does matter, because the Secretary of State, they say you can do X and X is prohibited. The person may point to that as part of their defence and say, well, I was following what I was instructed to do. But I think what the principles in A and in BF are, in my submission, a very clear judicial steer that it is those positive assertions of legal obligations which are vulnerable to judicial review, and silence on particular legal obligations, even if the same field is being covered in the guidance, does not amount to legal error, because there's no duty on the Secretary of State to advise.
This reminds me, and I will just mention this for completeness, but I think I guess what you were going to say. You haven't specifically addressed the question of the doubtful penalisation principle, which Sir Ross, when you were dealing with the construction of paragraph 29, which Sir Ross attracted some importance to. Or if you did yesterday,
My lord, no, I didn't spell it out.
it's in your skeleton.
It's in my skeleton.
And frankly, I'm not sure it admits of much development. But
my lord, it doesn't, and I think my submission really is limited to that the provision becomes absurd or unworkable, and in essence, you don't have to go on and say also leads to doubtful penalisation. So it's the context in which I'm inviting the court to say that Mr. Brown's submission is an absurd interpretation is what is ultimately a legal provision, in other words, that will leave something. But I think I can stop at absurdity and unworkability, which obviously the court should strive to ensure the statutes are not read in such a way.
yeah, okay, thank you. Sorry, back to code of practice.
Code of practice. So the code of practice, just to note, and this is important for where Mr. Brown goes in it, that the code of practice is concerned with meat chickens and meat breeding chickens. Now, those are two different things. Obviously, the breeders are kept differently. They're kept for the production of fertilised eggs, which are then going to be hatched into the meat, into the chicks that are going to go into the meat process. And the guidance is concerned extensively with the systems that are used. It does set out in some detail the relevant statutory provisions, and it does so just by way of format in these boxes that we see first at page 302, setting out some of the key regulations. We see then in the introduction at page 307 the first reference to paragraph 29, which just states paragraph 29 accurately. The paragraph before, paragraph 5, says the relevant animal welfare legislation owners, as well as any person looking after chickens on their behalf, protocols set out who's responsible, but the obligations of law still apply. And then paragraph 6, after paragraph 29, states strains of bird must be suitable for the production system.
Yes, the structure of this is rather odd, but when you get something in a blue box, does business as a heading, and the para or paras following it are the text glossing that heading or addressed to that heading. Is that right?
It's
a bit odd. I mean,
I'm not
else,
sure it's quite as simple as that when you follow it through, but because these paragraphs.
in this case, that's certainly how it works.
Yes, precisely.
I'm bound to say these codes of practice often adopt very fancy typographical or presentational things which make them more difficult to understand rather than make them less rather than easier. Anyway, there we are. That's how it works here.
That's how it works here. So that's the first mention, and then my learned friend took the court to paragraph 59, I think it was, and this is under the heading leg health. So it's dealing with a particular aspect of the care for meat chicken, and notes in paragraph 58 that it can be a key cause of poor welfare in meat chickens. And there, obviously, there's no distinction being drawn between fast-growing breeds and slower-growing breeds, and it's identifying the potential causes. And then paragraph.
Sorry, just being clear about, but this. Just coming back to what it. Is this under the general heading disease control and biosecurity on the previous page? I don't think it is it?
No, it's not.
It's a fresh heading, and therefore it's not directed specifically to any provision.
So if my lord goes back to page 309, there's a main heading, section 1, recommendations applying to all husbandry systems. So these are the recommendations that apply to free range as well as intensive rearing, to conventionally grown as well as.
I see. Yes, you get various headings: stock, staff, and catching and handling. Some of which have these red or blue boxes, and some of which don't. That presumably means that that particular subject matter is regarded as being specifically addressed by a particular provision, and where there isn't one, it's just there isn't any specific provision. Is that right?
Yes, I think there's precisely. I think there's particular points being pulled out.
Yeah. No, that's helpful.
I think what the pattern, so far as I can discern it, is that the boxes with the, I don't know what the word is, with the curved edges to the box, whereas it applies to all chickens. And the square edge box, I don't have a colour copy, it may be different.
Oh, I see. It's square. Let me tell you, the curved ones are blue and the square ones are red. Yeah.
So the red ones apply to conventionally reared chickens, so that that's where they're extracting from Schedule 5A.
Yeah.
So they'll apply to some, but not all, of the chickens that are being referred to in this section 1 of the code.
Yeah. Anyway, thank you. That helps with the structure.
In respect of leg health, my submission here is that, first of all, paragraph 59 is not about paragraph 29 of Schedule 1 of the regulations. It is about leg health specifically, and it is pointing out that one of the ways in which leg health can be addressed is from broad breeding programs which promote and protect health, welfare and productivity. And that, in my submission, is guidance that can perfectly lawfully be given without suggesting anything about the principle in paragraph 29. The fact that the phrase is welfare and health considerations in addition to productivity, in my submission, is just a recognition of the reality that the breeding programs are concerned with productivity. They're farming programs, they are about the production of food. But they should, and do, also seek to promote welfare outcomes and health outcomes. And as I said yesterday, those are all consistent with productivity, in fact, or often will be consistent with productivity.
So it's not saying balance productivity against welfare and health considerations. It's saying, although you are obviously concerned with productivity, when choosing a strain, you've also got to be satisfied about health and welfare. Is that
precisely? Precisely. And as my clients reminded me yesterday, of course, if a chicken arrives at the slaughterhouse with a broken leg, that leg will be removed and not go into the food chain. In other words,
that chicken will be removed?
Well, the chicken might be if it's diseased, but if there's a particular injury, then that part of the chicken might be removed. In other words, that you can't, if chickens arrive at slaughterhouse with disease or particular welfare conditions, you can't sell them into the market. It's not in the interest of the farmer to stock chickens which are going to have a particularly high instance of those problems because they can't sell them. So in my submission, there's nothing in that opines on the meaning of paragraph 29, and taking that high threshold in A and BF Eritrea, in my submission, you simply cannot reach the conclusion that there's anything that amounts to misdirection as to the law.
But I think as I understand it, the objection that's taken in paragraph 59 is not so much what it says, but what it doesn't say. It doesn't sort of give the person reading this any indication that at some point they would have to be alert to the fact that a particular strain of chickens just simply couldn't be kept because of the welfare and health considerations relating to leg size, and that it could easily be misread as suggesting that productivity could be just used as justification for keeping a particular strain of chicken, that health and welfare considerations would prevent you from keeping. And there's no warning that in an obvious place, leg health being the obvious one that we've been focusing on because of it's one of the two traits that is most identified in relation to the fast-growing chickens. So it's really what is said against you is it's what it doesn't say. The implication that there's no guidance to anybody reading this that there actually might be a hard line you just can't cross, and that somebody could easily get the wrong end of the stick here and say, okay, I can choose this strain of chicken because it's great for productivity, even though the health and welfare considerations are such that they shouldn't be kept. They can't be kept, lawfully be kept. And it just doesn't alert people to that possibility.
No. Well, my lord, two answers to that. One of them is just confined to the document itself without thinking about the law. The reader has already been warned about paragraph 29 in the introduction. It has been set out in terms in the introductory text to this section at page 307 of the bundle. So the reader knows about paragraph 29. Secondly, the lack of warning is exactly the kind of argument that the Supreme Court was saying you cannot run in respect of guidance. There is no obligation to warn recipients of guidance as the general law. So it's not a ground for judicial review to say that the guidance could have at that point warned of some other
does the Supreme Court tell us there's no obligation to issue guidance about the general law? But is that the same as saying there's no obligation if you do issue guidance in the field not to alert somebody to where the general law sits? I mean, I understand your first answer, which is that paragraph 6 of page 307 is an adequate warning. That's either right or wrong, but I understand that. But I didn't understand the Supreme Court to say. I thought the Supreme Court only was saying basically you don't need to issue guidance about the law, but that's not quite the same thing as saying if you do issue guidance, that you should make sure that it correctly identifies where the legal lines are.
If I can just go to the head note of A, page 663 of the bundle behind tab 18, there's a summary of the three circumstances that the Supreme Court said where a policy might be found to be unlawful. The first is a positive statement of law which was wrong, and which would induce the person who followed the policy policy to breach their legal duty. So paragraph 59 is plainly not in that category. Because as my Lord says, as high as it doesn't say, it doesn't remind him of paragraph 29.
Yeah, I think it was Mr. Brown really put his main emphasis on 3, I think.
Yeah. So where the authority, even though not under a duty to issue a policy, decided to promulgate one, and in doing so purported in the policy to provide a full account of the legal position but failed to achieve it. Well, and then it goes on, either because of a specific misstatement of the law or because of an omission which had the effect that read as a whole, the policy presents a misleading picture of the true legal position. So, first of all, the Secretary of State did not purport to provide a full account of the legal position. But secondly, he did set out the relevant provisions. So even if he was providing a full account, he did so because paragraph 29 is set out in terms on page 307. And thirdly, there's nothing then misleading about paragraph 59 because it makes there what is a legitimate point about taking into account the strain that's to be used without saying anything about whether some strains in some circumstances might fall foul of the general prohibition in paragraph 29.
We've probably dealt with page 327 as much as we can, or paragraph 59. Maybe other points you want to take us to, but the other one I'd just like to hear you about particularly is at page 332.
Yes. So,
which is the other place where paragraph 29 is referred to.
First point, so this is not about the chickens that we're concerned with in this litigation. So this is about meat breeding and grandparent chickens. So this is about the breeders as opposed to the chickens that are being conventionally reared for their meat. So first point, irrelevant to the evidence in the case that's being put.
So I'm just, sorry, could you just give me the paragraph again? I'm just trying to...
Page 332 of the bundle. Yep. So this is section 3, which is about meat breeding and grandparent chickens. And you see at 116, second sentence, noting that the husbandry requirements are quite different. So it's dealing with a different type of farming system. Paragraph 29 is set out, again, accurately in the box. And then at 117, the reference, I think, that Mr. Brown said was offensive was balanced breeding programmes promoting and protecting health, welfare and production goals simultaneously. In my submission, again, as I said about paragraph 59, there's nothing misleading about that. Birds should come from such breeding programmes. It's sensible guidance, entirely lawful. And it doesn't need to go on to say that if health and welfare are inevitably compromised in this type of chicken, then the prohibition at paragraph 29 may be engaged.
We come back to the problem that paragraph 29 is really about keeping.
Yes, but for these purposes, the code of practice doesn't say you can keep a chicken if it's good for productivity, but inevitably it will have detriment to its health or welfare. It's saying the opposite of that. It's giving useful practical guidance.
Anything else on the code of practice?
My Lord, no. Can I then just deal very briefly with the trigger system? And if I can just turn back to the regulations, tab 4.
You can, of course, but we've heard very little about it from the claimant, and therefore we're unlikely to be saying much about it ourselves, but subject to that, of course.
Can I just, one point from the regulations? So the purpose of the trigger system, paragraph 15 of Schedule 5A to the 2007 regulations, page 88 of the authority, authorities bundle, the purpose, this is both paragraph 15 and paragraph 16. We have paragraph 16? The purpose of the monitoring process that's effective for the trigger system is to identify core conditions on the holding. In other words, the trigger system is not concerned with compliance with Regulation 29. It's not targeted at that. But with paragraph 29, it's not targeted at that. It's looking at the conditions on the holding. Now, of course, it generates statistics which show the percentage of animals that suffer from certain welfare detriments. So, indirectly, you could use the output of the trigger system to form a picture as to how many of particular animals are suffering from detriment. But it doesn't, for example, record the strain of chicken that is going through the system. It applies to all chickens. So there's no distinction being made in the trigger system between fast-growing and slow-growing breeds. You would have to reanalyse that data to reach a conclusion on it.
And you would say the animal welfare conditions to which paragraph 15 refers are the kind of things dealt with in the previous paragraphs of Schedule 5A.
Precisely.
Density limits, drink and feed, litter, ventilation, etc., etc.
Precisely. The only other thing to say is that the trigger system, I think I mentioned this briefly yesterday, but in Ms. Thompson's first statement, and you'll have the references in our skeleton argument, the trigger system and its design and its performance is considered quite extensively by Ms. Thompson, because the ground formulated below was not linked only to paragraph 29, but alleged a wider failure of the trigger system, which is why I think it survives here only as an add-on rather than as a central ground. But below, Ms. Thompson dealt with in some detail the operation of the trigger system. So that's the trigger system. In terms of, I think ground 5 is not pursued in the same side argument, so I don't say anything about that. So coming back to ground 1, for the reasons I've given, there's no declaration to be made on the operation.
I thought Mr. Fulbrook was going to address us on that, but...
He was, but then nothing was said about it, so I don't...
Yes, no, sorry, I don't mind at all. I just wondered, I thought this morning you said you were going to leave it to him. Maybe I misunderstood.
Yesterday I said I had intended to, but I think we concluded that nothing.
I'm sure he can live with that.
I think he can, or at least he will. Yeah. Ground 1, then, which is about whether it's right to make a declaration. The first point I make is that the question of relief is a matter of judicial discretion. And of course, the judge exercised that discretion. See judgment paragraph 82. The second point is the point in which we set out in our skeleton argument at paragraph. I'm going to do this with skeleton, so it might be helpful to let you know. It's skeleton paragraph 39, and the reference is to Burke and GMC. And I've already dealt with that point this morning about the risk of making declarations when the point of construction is divorced from a factual context. The next point, logically, is that if in fact the objective is to resolve a legal dispute, which, as I've said already, the difficulty here is the slight ambiguity as to whether the court is being asked to give an advisory declaration on the meaning, or to say something about meat chickens that tries to resolve the dispute. And paragraph 40 of the skeleton sets out our response. If it is the latter, the court shouldn't try to resolve the dispute that Mr. Brown says exists for the reasons that were given in a very similar context in the Compassion in World Farming case, and that again is in the authorities bundle, and it's paragraph 49. And essentially it's that the court needs to be very cautious about findings that would hold a large number of keepers of chickens liable when those people have not had the opportunity to respond to such an allegation with a factual response. So that's paragraph 40 of the skeleton. And the particular point that I emphasise is that the RSPCA submit, and there was a hint of this yesterday from Mr. Brown, that in essence the court should just make a declaration and not speculate as to what might happen next. But in my submission, such declarations, that indicates that the declaration is not appropriate.
Isn't this a bit of, aren't we just a bit of shadow boxing here, really? Nobody is suggesting that we should not say in the judgment what para 29 means, and perhaps being a bit more helpful in saying it means what it says, i.e. addressing the various disputes about what it means. I don't see a real difference in substance between simply leaving it there and deciding not to make a declaration and making a declaration. It's basically a pragmatic point about whether anything we say in the judgment is helpfully formulated as a declaration.
Well,
the points you're making, if they were that extreme, would mean we shouldn't rule at all on the point of construction, and nobody's suggesting that.
My Lord, that's right. I suppose there's a practical point, which is that we say, for all the reasons given by the judge, including his refusal to give any declaratory relief, this claim for judicial review was rightly dismissed. And in other words, that the appeal against the judge's order should also be dismissed. So essentially, that this court should not conclude that the appeal should be allowed merely for the purposes of making an...
Well, I see that may have cost consequences, but all these things, it may be that the outcome of all this is that, although we may give a provisional view at the time we circulate our draft judgments, that the question of the form of the order may depend on what we say in the text.
Yes. Well, I think what I say about that is that so far as any declaration would seek to deal specifically with the facts that are before the court, so far as they are, I would say that would be inappropriate.
We've got your submission.
Fashion and world farming, also the facts of, if they're Mr. Brown's facts, they're disputed. So far as there are no facts, there's no need to make a declaration because it serves no purpose, and the judge was right in his discretion to reach the same view. The final comment I make about relief is that it's, in my submission, inappropriate to comment, as Mr. Brown suggested, on what the Secretary of State may or may not do once informed by the court's opinion on the matters. And that is a constitutional point because Parliament has entrusted that decision-making to the Secretary of State. So
the declaration would only be a declaration. Nobody's suggesting we give an granted injunction which would tell the Secretary of State what to do.
No, but it was suggested yesterday that there might be some comment on what the Secretary of State might have to do in terms of practice or whatever it might be. But in my submission, that would be inappropriate because Parliament says it's for the Secretary of State to decide how to go about it.
Well, it depends. Maybe, I can't remember exactly what Mr. Brown said. It would be a matter for our judgment whether we spelt out the obvious, but the Secretary of State will no doubt wish to reconsider his questions of policy or code of practice in the light of this construction. Reconsider doesn't mean come to any different conclusion. It just means look at it again.
Well, my Lord, I say that. I take the point, but I do say that in itself would be inappropriate because if all the court has is a construction to opine upon, then what the Secretary of State does with it is vouchsafed for the Secretary of State. Parliament did not intend the court to say, and as a result, you must again think about your code of practice.
So you would say, for example, that we should not say that the Secretary of State has an obligation to reissue the Code of Conduct, giving guidance about paragraph 29, because it's a discretion and not a duty.
Yes, and the discretion to amend and revoke is also discretion, not a duty.
And if we conclude there's anything in the Code of Conduct which is unlawful, then obviously we can say that, with whatever consequences will follow. But that's, you say, as far as we should go. Is that right?
Yes. Yeah, and just to emphasise, my name, Gina reminds me that there is that Section 15 of the Act on the Code of Conduct. It's not just the Secretary of State. There's a parliamentary process and a process of consultation. So these codes are not just a sort of statement of policy that can be worked up and amended day to day.
Well, of course, they would have to go through a process.
There's a
yes,
parliament.
Thank you for reminding us. But yeah, thank you.
Unless I can assist further.
Mr. Burnley, I know the deal is you have 20 minutes. You don't have to take 20 minutes, but you may wish to.
I will not take 20 minutes, my lord, and that's because happily I can endorse and adopt Mr. Turney's submissions. I'd also ask the court to read my skeleton argument, which was submitted prior to the respondent's skeleton argument because of the way the timing worked when we were granted permission to participate. But happily, that's also consistent with what Mr. Turney has said. So all I want to do today is make two additional points that are short and I hope helpful.
I'm sure.
The first relates to the definition of phenotype, which is not just in my submission a point of a detail, but it's actually of some importance. I don't want to disparage Mr. Turney's very impressive extempore definition, but the actual importance of phenotype isn't just that it's how the genotype manifests itself. It's how the genotype manifests itself in interaction with the environment. So what that is actually telling you, in the terms of paragraph 29 itself, is that it's not just the genetics that matter, it's how the genetics interact with the particular environment. And that, in my submission, is a powerful pointer towards the construction that Mr. Turney, and indeed myself on behalf of the NFU, adopt, which is that the environment matters. It's not just you assume a hypothetical environment and ask that question, because what you've actually got to focus on, and bearing in mind this is a provision that's directed at the individual keeper, is that keeper's got to ask themselves, can I reasonably expect, knowing what is known, reasonably known, about this particular genotype and how that will interact with different environments.
So does that mean that phenotype doesn't include how the genotype manifests itself in behaviour?
It would, in terms of it would, because that's an environmental factor. How an animal behaves is how if there's a genetic, let me put it this way, if there is a genetic reason why a particular animal will behave in a particular way in a particular environment, that is part of its phenotype.
Yeah, no, it's the last bit. If it would behave in a particular way irrespective of its environment, is that caught by the
no, it is, my lord. Yes. So environment. So the environment is once it's living. How's it going to behave? And if the answer is it doesn't matter, because it's always going to behave in a particular way irrespective of the environment, that would still be part of the phenotype.
Okay, so you're not suggesting that phenotype is limited to interaction with environment?
No, my lord, no.
It just includes.
It includes. No,
Thank you.
Quite so. And just to underscore, again, that this provision it's a broad provision that applies across the board. It's not just about chickens, it's about animals. Every animal has a genotype and a phenotype. So it's not possible, and this was a point Mr. Turney made yesterday, to say, well, it's about marginal differences or because you've only got 1% or 2%. It's a question that the keeper's got to ask themselves, and in the case of a prosecution defend themselves by basis of what's known about that particular animal's phenotype and genotype. And this is relevant when one comes to address Mr. Brown's submission that, well, as soon as you have anything that you can say there is a reason that can be, he phrased it as a causal link, that the reason why you have this particular issue is because of the genotype or the phenotype, you can't keep them. Because if that was so, there would be no farmed animals whatsoever, because that's always going to be the case, that there are pigs will have a particular genotype and phenotype. There will be certain things that inevitably, because it's in the nature of being a pig, that you're going to be susceptible to. And you're going to be susceptible to whatever the environment. It's the same with all animals. And if you take that extreme case, and Mr. Brown does put it that high, you really would have absurd consequences. And this is why I do endorse what Mr. Turney says about the need to test, not just as, of course, your lordships must, by reference to the particular hypothetical that Mr. Brown has put before you, but all of the circumstances in which this provision is going to have to apply. Because it might be said, applying by parity of reasoning, Mr. Brown's argument, that actually you have a report from the SPCA, well, actually, not the SPCA, but from a particular group who's done some scientific research that says these particular animals, by their nature, have pigs, all species of pigs, have some particular welfare issue that's just inherent in pigs. And this was inherent in, was something that your lordships, a concept that your lordships were talking about yesterday. Well, that would be caught by paragraph 29 on Mr. Brown's construction. Because that would be something that's referable to the genotype and the phenotype of all pigs. Still be caught by paragraph 29. So it simply can't have the meaning Mr. Brown says it does. So that's what I say about that. The second point is just, I hope, to help you not have to receive more paper. And that is, your lordships asked about what codes of conduct there were out there from the respondent. And Mr. Turney will be able to just nod if I've got this, correct. This is just because I had the benefit of being able to go to the DEFRA website. It's laying hens, broiler in parentheses, meat chickens, ducks and turkeys. That's one code of conduct that there is. Cattle, that's beef cattle and dairy cows. Then pigs, which includes breeding sows. It's not a long list. Sheep, which includes milk sheep. Goats. Deer, and then in parentheses, farmed deer only. Rabbits, in parentheses, farmed rabbits only. And then game birds reared for sports purposes.
Yes, I see.
And that's the list.
Good, thank you. So effectively, for all the commonly farmed breeds,
as you would expect,
there are codes of practice.
Quite so.
Yep. Thank you very much indeed. Well, Mr. Brown, you will get Mr. Birdling's economy means we, with a bit of luck, won't have to go into the short adjournment.
But no, we won't. I'll finish before the short adjournment. I'll take the points, broadly speaking, in the order that they were made. First point, it was suggested by the Secretary of State that for judicial review, one needs a decision. In fact, the general approach is that one needs a target for judicial review, and we have very much formulated a target. It is legitimate to ask this court for an authoritative interpretation of the statute. Jurisdiction is section 31(1) of the Senior Courts Act 1981, and the test is whether it is just and convenient for the court to give that interpretation. See the authorities set out in paragraph 28 of our skeleton argument, but more specifically, where that has manifested in a code of practice, then that too is a legitimate target for judicial review. So we say that the Secretary of State certainly expresses the principle too narrowly. It isn't the case that we need to somehow elicit a decision in the form of a letter from the Secretary of State as to what they say and therefore challenge it. in the same way that one sometimes sees in tax cases, where you get a decision from the revenue and then you use that as a framework for your challenge. There's a broad concept, and we are squarely within it. Next point, the interaction between the Animal Welfare Act 2006 and paragraph 29. Given the very central importance that is now placed on this by the Secretary of State, it is, we say, important to have regard to the legislative history, which I opened the appeal with. So true it is that the 2007 regulations are made pursuant to the enabling power in the Animal Welfare Act 2006. What is also right to note is that the directive on which those regulations are based substantially predates the Animal Welfare Act 2006. It's the 1998 directive, that's tab 1. And as a matter then of legislative history, that is implemented, the United Kingdom's obligations are implemented by the WOFAR 2000 regulations.
Hang on. So WOFAR 2000
Yes.
was enacted under the European Communities Act.
In fact, I can tell the court precisely because I've handed up an authority, which is Gray, R. Gray and Crown Court at Aylesbury.
Right.
And there's a little bit of legislative archaeology at paragraph 31 in Lord Justice Toulson's judgment at 826. And what one sees then is that section 9 is completely new in 2006. But the judge makes reference...
Sorry, section 9 of what?
Sorry, of the Animal Welfare Act 2006.
Oh, I see. Sorry, I was thinking it's an older authority than it is. Yep.
Yeah.
Yep.
Then the judge says, and this is paragraph 31, fourth line, some animals have been protected under the WOFAR Regulations 2000, made under Part 1 of the Agriculture Miscellaneous Provisions Act 1968, and no doubt also the European Communities Act. So that process of identifying all legislative basis regulations was tightened up slightly later. It says this was an example of the earlier piecemeal nature of animal welfare legislation. So the point for our purposes is that paragraph 29, in precisely the same form, and we have it if it would be of assistance, was on the statute books from 2000. So we say that it is wrong to characterise Section 9 as a primary obligation with paragraph 29 sitting as a backstop behind it, because it comes onto the statute book as a matter of European law, whereas the Animal Welfare Act 2006 is United Kingdom domestic law, and it is therefore right as a matter of parliamentary intention to note that it is indeed a freestanding set of provisions originating in the European community that regulates farmed animals. So it is inherently improbable that the EU legislature, which adopted this provision originally, intended for it to operate as a backstop to some particular future domestic legislation enacted in a single member state some 6 years subsequently. That is obvious as a matter of common sense, but in response to the submissions, that does not allow you to effectively read down paragraph 29 as operating as some form of backstop because of the existence of section 9. With that, though, if I may ask the court to turn back to section 9, because it's a very important point of principle, and indeed it could be said that this is the real nub of the distinction between us. This is Authorities Please, page 46, tab 3, page 46. And the obligation emphasised by the Secretary of State is section 9.1. A person commits an offence if he does not take such steps as are reasonable in all the circumstances to ensure that the needs of an animal for which he is responsible are met to the extent required by good practice. So we say that that plainly covers the situation, for example, of animals that do not welcome the cold. It has been good practice for millennia to keep them inside during cold weather. But what section 9.1 does not say is that you take the position that the breed cannot be kept no matter what you do, which is the formulation that Mr. Turney adopts for the Secretary of State. There is a readback to good practice, and we would agree with the NFU that in this respect then the environment matters, and what in fact one is considering, what we say are ordinary commercial farming conditions. They are set out in the regulatory framework, and then they are encapsulated in the good practice, the best evidence of which is the code of practice. That is a very substantially lower threshold than that which is glossed by the Secretary of State in this appeal, who says that, in fact, that should be read as meaning that the keeper does everything that is realistically possible. Simply not what section 9.1 says. The offence does not occur if the keeper has failed to do everything that's reasonably possible. The no matter what you do type of...
Surely, why are we looking at section 9 at all from this point of view?
Yep.
Reg 29 is a separate...
It must be a separate provision. Why are we looking at it at all? Because there is a passing reference to it in the defendant's skeleton argument at paragraph 51 on page 20. Certainly the judge didn't see that section 9.1 was the key to unlocking this regime, which is very much how the Secretary of State puts it now. He says, look at section 9.1, that's your primary obligation. If you've done everything required by section 9.1 as glossed by the Secretary of State, so the all reasonable steps as opposed to simply the reference to good practice, and you still cannot keep the animal, then you resort to paragraph 29. That's the Secretary of State structure.
That wasn't, just to be clear, I gave section 9 because it's part of the context. The other part, of course, is regulation 4, which is in the directive, which has the same provision. I made the point that the two could be equated. So,
Well,
the leaping off point is wrong here.
thank you, Mr. Turney.
Well, the court will have its note, but we say that the Secretary of State does say that the starting point is section 9, and that operates as a primary obligation, and paragraph 29 sits behind it. And that simply cannot be right, and it must be interpreted, we say, as being an independent regulatory regime that applies to farmed animals. As to the point that's just been made on by the Secretary on his feet, so is it the same as regulation 4, which appears at 76? It is not. So we would accept, of course, that regulation 4 of the regulations is part of the framework. This is page 76. That simply says then, the person responsible for a farmed animal must take all reasonable steps to ensure that the conditions with which it is bred or kept comply with Schedule 1. Then subsection 2, in complying with the duty, a person responsible for a farmed animal must have regard to the matters stated. So the Secretary of State's interpretation that one then reads in that you take all theoretically possible steps in order to address the issue, we say, is not found on the face of Regulation 4 either, so there's nothing of the sort. That is presumably why the emphasis has been on section 9.1, because it becomes much closer to saying that, albeit the reference is to good practice as opposed to the all reasonable steps, which is how the Secretary of State puts it. So the structure, which is integral to the Secretary of State's argument, is simply not right. What section 9 also does is create the difficulty that by referring to good practice as being the test, one has to then understand, well, what is that practice? And the difficulty one has here is that it becomes circular, because the best evidence of the practice is the code of practice. And the code of practice, as we have seen, does not then tell you anything at all about the particular issue of fast growth chickens or other animals that might be in a similar category. So we are, as we have complained from the outset then, essentially in a legal no man's land, because if one is looking at section 9 as being the starting point, one has to say, well, what is the practice in question? And so there's nothing in the code of practice. Secretary of State's follow-up point is, well, look at the feeding instructions from the sellers of the animals, for example. And we say, well, that, which is a new point, is an extremely tenuous basis for asserting a practice. The truth of the matter, and this has not been the subject of any particular inquiry or investigation in this litigation, that the instructions on keeping that come from the vendors of the animals are going to be directed towards things like the amount of feed required to achieve the 50 gram per day increase in body weight, as opposed to some sort of cautionary warning that the very breed that is being sold by that seller may itself be in contravention of paragraph 29. That's simply unreal. My final point on this is that this also does reveal the fact that the judge has not grappled with this, because this analysis, even if it is correct, which we say it plainly isn't, forms no part of the reasoning below. So one would think that the Secretary of State would be asking this court to set out a very different statement of the law, given the difference between what the Secretary of State says here and how it's been articulated by the judge below. More specifically on paragraph 29, it is obviously intended to respond to mischief. So that is, we would say, obvious. The issue then is, what is the mischief? And we say that one knows that there are genotypes or breeds that are problematic. Otherwise, Parliament, the EU legislature, would not have intervened. And fundamentally then, this is not about individual defective animals. This is about genetic inevitability, which is established by the science. And my Lord Justice Underhill is right to identify then that envisages a distinction between things arising from the vicissitudes of life, so the fact that something might just be inherent in general terms, and things that can be scientifically linked back to that process of selective breeding and the creation of new breeds, which have themselves developed then certain difficulties in the genotype. And that is the mischief which this legislation is directed towards. And what that means in practical and real world terms, which the parties all now agree, is that fundamentally it is about choice of breed by the keeper today. So this is paragraph 1 of our declaration, which is now agreed. So the touchstone is that the keeper has to determine today what is reasonable based on the scientific knowledge today and in light of the breed choices available to them. So as Mr. Turney puts it, this is an emerging picture that changes over time. We would agree with that description. One doesn't need to go back through the history of farming to the auroch or the jungle fowl. One looks at the choices that are presented with the scientific literature available today and the keeper then makes the decision, knowing what can reasonably be known, as between those different breeds that are available.
I think your formulation, I think you said the keeper had to decide, originally you said the keeper had to decide what is reasonable based upon the scientific. I think actually it's the keeper has to just make a choice based upon what he can reasonably expect given the science.
Yes, absolutely so. So he has to make a choice based on what would reasonably be expected by reference to the science. So drawing that together and by reference to our declaration, where is the common ground and where is the dispute? 1, 2 and 3 are broadly speaking now not disputed. There's a bit of quibbling in relation to the third issue, whether it's properly described as conditional permission. Where the battleground appears to sit fundamentally is our fourth paragraph of the declaration. Reasonably be expected means what will be expected by a keeper operating in ordinary commercial farming conditions. So if we are right about that, then the choice with which the keeper is confronted, one assumes an ordinary commercial conditions.
I think this is a test we always have on a Thursday, isn't it?
No.
Attention, please. Attention, please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers.
But I think we have to take this seriously. I think, assuming the problem has solved itself, we will reset at 2 o'clock.
Hello.
Attention, please. Attention, please.